India possesses a constitutional framework designed to prevent political defections. Despite this, governments frequently collapse, parties fragment, and legislators openly switch allegiances. The critical question is no longer about the motivations behind these defections, but whether India's anti-defection law retains any practical efficacy in contemporary politics. Has the political landscape simply evolved beyond its reach? India's anti-defection framework is enshrined within the Constitution, specifically the 10th Schedule, which was incorporated in 1985. This legal provision aims to curb political instability caused by individual legislators changing parties. The fundamental principle is straightforward: an elected member of parliament or member of legislative assembly faces disqualification if they voluntarily relinquish their party membership. Disqualification also occurs if they defy the party whip during crucial voting sessions in the legislature. Initially, the law was conceived to address specific political maladies. It sought to end the "Aaya Ram, Gaya Ram" phenomenon, characterized by frequent party switching. The law also aimed to prevent the collapse of governments due to opportunistic defections. Furthermore, it was intended to curb the practice of horse trading among legislators, which undermined democratic processes. On paper, the anti-defection law presented itself as a robust deterrent against political opportunism. However, its practical application has revealed a different trajectory. In its nascent years, the anti-defection law appeared to achieve its objectives. There was a noticeable decline in individual defections, suggesting a greater adherence to party lines. The act of floor crossing became significantly riskier for legislators. This initial success led to an observable increase in party discipline within legislative bodies. For a period, the law seemed to function as intended, fostering greater stability. However, the dynamic nature of politics meant that adaptation occurred swiftly, often outpacing the law's static provisions. Modern political maneuvering has found sophisticated ways to circumvent the anti-defection law, primarily through mass defections rather than individual ones. The law permits a merger if two-thirds of a party's legislators defect together. This provision transforms individual switching into a collective movement, which is technically legal. Consequently, we now frequently observe blocks of 10, 20, or even 40 MLAs moving together. While legally permissible, this strategy is politically devastating for the affected parties. Another prevalent workaround involves strategic resignations. Legislators resign from their seats in the House, thereby avoiding immediate disqualification under the anti-defection law. This action triggers by-elections for the vacated seats. These former legislators then contest the by-elections from a new political party. This method entirely bypasses the disqualification clause, as the law never explicitly anticipated strategic resignation as a loophole. A critical vulnerability in the anti-defection framework lies with the Speaker of the Assembly or the Lok Sabha Speaker, who is responsible for disqualification decisions. These speakers are often active politicians themselves, typically belonging to the ruling party. This inherent conflict of interest frequently leads to significant delays in adjudicating disqualification petitions, sometimes extending for years. In numerous instances, these prolonged delays allow governments to survive their terms. By the time a decision is finally rendered, new elections may have occurred, rendering the original cases politically irrelevant. The Speaker's partisan role thus undermines the law's intended swift and impartial enforcement. The Supreme Court of India has repeatedly acknowledged the systemic issues plaguing the anti-defection law. Key rulings have emphasized that speakers must act within a reasonable timeframe when deciding on disqualification petitions. The court has also asserted its power to intervene if delays are found to be malicious or politically motivated. However, the Supreme Court has also maintained that it cannot rewrite the Constitution. It has consistently stated that fundamental reforms must originate from Parliament itself. Consequently, the anti-defection law technically survives, but its enforcement remains notably weak and inconsistent. This situation presents a profound paradox within India's democratic framework. The Anti-Defection Law, while aiming for stability, inadvertently punishes legitimate dissent within political parties. It effectively stops members of parliament from voting against their party's directives, even on matters of conscience. This rigid enforcement limits healthy debate and deliberation within legislative bodies. By demanding strict adherence to party lines, the law weakens the individual conscience and independent judgment of elected representatives. It prioritizes party unity over the legislators' duty to their constituents or their own convictions. The short answer is yes, the anti-defection law can still work, but not in its current form. Experts have proposed several reforms to enhance its effectiveness and fairness. One key suggestion is to replace the Speaker with an independent tribunal for disqualification decisions. This would remove the partisan bias inherent in the current system. Another reform involves setting time-bound decisions, perhaps within 30 to 60 days, to prevent deliberate delays. Furthermore, some experts advocate restricting the application of anti-defection provisions only to critical votes, such as confidence motions or money bills. This would protect governments while restoring legislative freedom on other matters. Such reforms would protect governments from opportunistic defections and restore legislative freedom. They would also significantly reduce political manipulation. However, implementing these changes requires broad political consensus. No ruling party immediately benefits from such reforms, leading to a persistent stalemate. Consequently, the necessary overhaul of the law continues to stall. The anti-defection law is not entirely defunct, but it is undeniably outdated. Indian politics has evolved significantly since its inception. The landscape has shifted from individual acts of betrayal to highly organized realignments of entire factions. Laws designed for the first era are simply inadequate to regulate the complexities of the second. Until comprehensive reform is enacted, defections will remain a legal, tactical, and often decisive tool in Indian politics. This is not because the law is absent, but because political actors have learned to skillfully navigate and outgrow its limitations. From personal ambition to external pressures, from electoral predictions to constitutional failures, this series reveals a clear truth. Indian politics is no longer merely about individuals switching sides, it is fundamentally about switching entire systems.